Yesterday, yesterday we talked about unique legal issues that arise from the unique nature of the internet. I didn't try to take any side on those legal issues. Today, I'll be taking the side. I'll be taking one side, the side of human rights. Human rights provides answers, not correct answers, but their own answers to the legal issues, legal questions posed yesterday. Human rights doesn't address all of the legal issues that arose yesterday, but it does address some of the issues. So, what is human rights? Human rights has built-in international character. It's often compared, it's often contrasted to national rights. So when you say human rights, we are talking about international rights in a sense that people of all countries, in a sense that human rights are rights that people of all countries and all nations should enjoy at minimum. So human rights are like the minimum rights that everybody in any region, any nation state should enjoy. The term human rights was first coined in a serious manner, not as a joke, comparing to animal rights, but in a serious manner in 1948 Universal Declaration of Human Rights. Why did we have UDHR? Because people over the world found out through the experience of World War II and the Holocaust and other travesties of human cruelty, realized that the values like democracy, the values like patriotism, values like people, values like communism cannot stop clear human cruelties. People thought that they need a new concept that can stop these cruelties. So UDHR was a document approved by the General Assembly, UN General Assembly, as a global response, to the tragedies that accompanied World War II. So, for instance, just giving you an example, this is not the central article. There are many articles in Universal Declaration of Human Rights, including freedom of speech, privacy, but one article stands out for you. It's Article 7. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. Incitement is done through communication and internet, and internet is about communication. So Article 7 is of particular importance to us, and I'm going to come back to that. After UDHR was ratified, UN spearheaded ratification of another human rights treaty called International Covenant on Civil and Political Rights. It's often called ICCPR. It is a treaty. It's not a declaration. So it's supposed to have more binding force as to the parties that ratified it. More than close to 200 countries have ratified ICCPR, and ICCPR has many provisions, including freedom of speech, privacy, also this Article 19, which corresponds to Article 7 of UDHR. Any advocacy of national, racial, religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Again, incitement is a form of communication, and ICCPR specifically requires the contracting parties to ban incitement to national, racial, or religious hatred, which poses some obligation on the people running the internet, because the internet expands the scope and reach of communication. Therefore, it also expands the scope and reach of incitement to racial hatred or religious hatred. You can think of propaganda of ISIS and how well IS is using the internet to recruit young people around the world. There are other human rights treaties: International Covenant on Economic, Social, Cultural Rights, and Convention on Discrimination of All Forms of Discrimination Against Women, Children's Rights Convention. All these treaties impose obligations on the state parties that join the treaties to protect certain rights or to facilitate and enable certain rights. So these are the documents, these are the norms, but who guards the compliance to these norms? The first one that comes to my mind is, well, the first one that should come to your mind is UN Human Rights Committee. UN Human Rights Committee is empowered to monitor the state parties' compliance with ICCPR. And as far as the internet is concerned, ICCPR, I believe, is the most important human rights treaty. Other than ICCPR, ICESC, International Covenant on Economic, Social, and Cultural Rights, also has some bearing on the internet, because there the treaty is designed to protect people's right to cultural life, and internet now is at the center of cultural life of a lot of people. But that argument has not really made into the mainstream human rights decisions yet. For instance, not having access to the internet has not been considered human rights violation under under the Covenant on Economic, Social, and Cultural Rights. There are many people arguing that no access to the internet should be considered a human rights violation, but has not become mainstream yet. But if you look at ICCPR, freedom of speech has direct relation to the internet when things are taken down online. So that's why I think that UN Human Rights Committee is a central body when it comes to the relationship between human rights and the internet. Now, each treaty has its own committee. So the Covenant on Elimination of Discrimination Against Women has its own committee that monitors compliance with that treaty. Children's Rights Convention has its own committee monitoring compliance to that convention. Now, these are independent experts. These are not diplomats. They don't take orders from their own governments. And they hold deliberations, periodic deliberations on various states, in various member states in a certain order, because they cannot review all 200 countries at a time. They do it in a staggered fashion. So, for instance, Korea was reviewed 5 years ago and was reviewed again last year. So that's Human Rights Committee. And another body that sounds similar but is far different is Human Rights Council. Now, this is an arm of the UN General Assembly. So you heard of UN Security Council, right? Which is actually, in terms of physical power, has the strongest power in UN bodies. UN Security Council can issue resolutions disciplining, for instance, North Korean nuclear testing last week. Just like that, there is a UN Human Rights Council, and it is an intergovernmental body elected by the UN General Assembly to look at the human rights issues. And UN Human Rights Council conducts its own periodic review of UN members on human rights records. It doesn't look at whether, well, I mean, it does, but their role, the Human Rights Council's role, is not to check compliance with any treaty like ICCPR, but just all general human rights issues. But the review is done by government representatives, diplomats. So imagine how political it can be. So often, Human Rights Council issues many resolutions denouncing Israel, because Israel is outnumbered in the UN General Assembly. Of course, also because there are many human rights violations committed by Israeli government, but Human Rights Council has been also deemed partial, because it is conducted. The deliberation is conducted by diplomats with political interest of the governments represented by them. So, but another body from UN is considered more independent is UN Special Rapporteur. Currently, there are now special rapporteurs are, they are reporters. They report on certain issues around the world to the UN General Assembly, well, more directly to the UN Human Rights Council, but later to the UN General Assembly, and there are 26 special rapporteurs, 26 thematic special rapporteurs. So there's one on there's one on freedom of speech, and there was a new one appointed post-Snowden revelation on privacy. And these special rapporteurs travel around the world, look at areas of interest, look at certain regions with a crisis on human rights, and write their reports. And these reports are also considered good sources of human rights law. So internationally, the decisions made by the UN Human Rights Committee and also reports of UN Special Rapporteur, these two this one and this two, this one and that one, I believe are the most important documents, the most important sources of international human rights law. And then when it comes to regional law, regional human rights law, European Court of Human Rights has its own, makes its own decisions on human rights and Europeans. American, for some reason I cannot retrieve the name, but there is a similar regional body for Americas, North and South America, and then there is a similar regional body in Africa. Unfortunately, there is no such body covering Asia. That is a big homework for human rights experts in Asia, because these regional bodies play an important role in leveling the human rights conditions of different countries in the relevant regions, but we don't have such a body in Asia. So again, these regional courts like European Court of Human Rights is also another body that guards human rights. The relationship between the human rights and internet mirror the legal issues that I talked about in yesterday's class to a certain extent. The first one, of course, is freedom of expression. Internet expands freedom of expression of all people, all companies, and even governments have greater power in manipulating people's opinions through the internet. So the question is, should freedom of expression be restricted more since there is a more expression out there, or the same rules should apply? What's relevant is ICCPR Article 19. Privacy. Well, because there is more communication, there is a more chance of exposure. And some of the apps facilitate communication by leaving records, like chatting apps. Voice communication. In voice communication, your messages evaporate into thin air as long as you deliver the message, but chatting apps leave the records. And they leave the record, but that aspect of leaving the records is the core essence of that app, because it makes it convenient it makes communication much more convenient. You don't have to check the message right away. You can check the messages later. But that opens up more chances for privacy infringement. So what shall we do? Shall we allow more restriction on privacy, or the same rules should apply? ICCPR Article 17 protects privacy. How about freedom of association and anonymity? Again, freedom of association has been greatly expanded through Facebook and social media. The flip side of that is there are a lot of people who will come online without any association or affiliation. And not having affiliation or association is considered their way of affiliating. So no affiliation, no identity is how some people want to shape their identity. And so there is so much more anonymous speech online. Shall we allow, since there is so much, shall we just allow, restricting a little bit of that? Shall we just, shake that off as a very minor setback and not be so much worried about laws restricting anonymity. Next one, I'm not going to go into it in great depth, but just wanted to point out that International Covenant on Economic, Social, Cultural Rights, Article 6 protects the right of everyone to the opportunity to gain his living by work. How is this related to the internet? Well, internet creates jobs, but takes away jobs as well. Uber allows people without jobs to make a living if they have cars. But Google and other portals have made media companies go bankrupt because they no longer could not get advertising revenues, because people will read newspapers not buying paper newspaper, but by going online. So advertising revenue is shifted from media companies to online companies. So it destroys some jobs as well. So we should think about what role the internet can play in protecting the right to work. ICSC also protects right to education and right to cultural life and scientific progress. The role that the internet plays in these areas is, of course, great, but I'm not going to go into this in detail because there has been no authoritative applications of ICSC to the internet's role or the obligations of the governors of the internet to these basic rights, like right to work, right to education, and right to cultural life. Okay, free expression. One question that you can start your thinking about free expression is, when can you hold the speaker liable? When can you hold the speaker liable for how the hearer or the listener responds to his or speech? Speech is intellective. Speech is different from physical action. If I push somebody, then my action of pushing includes the component of the person being pushed. But if I say to person next to me, if I ask person next to me to push that other person, depending on how the listener responds, it can result in actual push, or it may not result in the intended action. When can you hold the speaker liable? When speech is intellective. Well, the US jurisprudence has settled on this concept of clear and present danger. And it originates from J.S. Mill's harm principle. And harm principle is that your freedom ends where another person begins. Okay? So you can enjoy freedom only to the extent that you do not harm another person. The flip side of that is you can enjoy freedom as long as you want, as long as you don't harm another person. And when that was translated into jurisprudence, the US courts have said, okay, speech will not be restricted as long as it doesn't have clear and present danger of creating physical effect. As long as speech doesn't cause, or as long as speech is not likely to cause harms, it will not be restricted. Now, the UN bodies have concocted its own test. Speech can be restricted only when it is necessary for a democratic society. There are other requirements, but I find this central. So, speech can be restricted only when it is necessary for a democratic society. Now, so there is this US test of freedom of expression, and there is this UN test of freedom of expression. Can they be reconciled? I think they can be reconciled. Many people see it as not reconcilable, but I see it as reconcilable. And also on freedom of speech, the US jurisprudence requires ban on chilling effects. So speech so vague that people don't know how much they can speak and how much they should stop speaking, when they should stop speaking, so that people will be afraid of brinkmanship. So people will stop much earlier. People will stop speaking much earlier than when they should stop. So that that allows a lot of lawful speech to be chilled. That's the chilling effect. So the U.S. jurisprudence requires that speech regulation should not have chilling effect. The UN centered human rights law also has similar element that any speech restriction should be clearly stated in law, and the clarity, required clarity is the required clarity should be to the level so that people know what speech is prohibited and what speech is not. And both US jurisprudence and UN jurisprudence agree that prior censorship should be banned. And by prior censorship, they mean the system where you submit the content of your speech for review by officials so that it can be reviewed by officials to decide whether speech can go out or not. Now, the result of this, I mean, I talked about the US jurisprudence just to illustrate the UN-centered international human rights principles. And the result of the UN-centered jurisprudence on human rights resulted in these low-level principles. The first principle is that there should not be no crime of false news distribution. So any law that punishes a person for distributing a false message is considered violation of human rights. And people will wonder, oh, punishing falsity, I mean, what's wrong with that? But the history has shown that many authoritative governments and dictatorial governments have made false news crimes and used those crimes to actually suppress truthful critics against the governments. And another way of looking at it is, if speech can be punished or restricted just for being false, there are just so much speech, online or offline, that has not been proved to be true. All religious statements. I mean, religion is religion because it has no empirical basis. I mean, if any religion is based on empirical basis, it will not have the magic power of attracting all those followers. Religion is meaningful because it challenges people to take a leap of faith beyond logical possibilities. So many statements, many tenets in religion don't have any basis, don't have any empirical basis, are not subject to verification. Should all those statements be tested against the crime of false news? So that's one principle. And the second principle is the state parties should stay away from criminal defamation. There are many countries that have that punish people for defaming others, and punishment comes in the form of criminal indictment and incarceration. And UN Human Rights Committee doesn't like that. Why? Because, I mean, think about it. My reputation, right? What is my reputation? Do I own it? Is it in my brain? Is it in my heart? What is my reputation? My reputation resides in your perception of me, right? My reputation resides in your mind. And it is beyond my control. So this theory that defamation destroys something that uniquely belongs to you has a limit. The second reason that you should stay away from criminal defamation is who prosecutes. Criminal defamation is prosecuted by the government officials that will be easily influenced by the people, the person who hold the power. And criminal defamation the history has shown that criminal defamation has been used again by many authoritative governments to suppress people and voices critical of the governments. Same thing with, so there are other rules that arose from free speech, UN-centered free speech jurisprudence. The third one is no truth defamation. I'm not going to explain why this rule arose because it's pretty obvious. And also no criminalization of statements not subject to verifications. What does UN Human Rights Committee mean by statements not subject to verification? What are statements not subject to verification? How about a statement that K.S. Park is handsome? Is this subject to verification? Yeah? Jim is nodding. Thank you. But these are statements that are not subject to verification. So feelings and opinions. So expressions of feelings and opinions should never be criminalized. Now, there is a U.S. Supreme Court case that illustrates this point very well. Back in the 60s, people were, against their will, drafted into military to fight in Vietnam. And I mean, imagine, I'll say Americans are the most individualistic people of the world, of the whole world, and yet they are forced into these positions where they should either kill others or be killed, right? Just imagine the anger of the people being forced into the draft. So one such angry person wrote on his jacket this phrase, "Fuck the draft." And the draft is the process whereby people are forced into military service. The police arrested him on disturbance of public order, things like that, and the Supreme Court said, free him. The Supreme Court acquitted him of the charge, saying this. Number one, speech serves a dual function. Speech conveys discrete information, but also speech expresses feelings and opinions. Number two, certain feelings are so tied to certain words that you have to use that particular word to express that feeling. Number three, if certain words cannot be used just because other people find it offensive, then people cannot express those feelings tied to those words. So if you start suppressing people's vocabulary just because it is offensive to some people, then that is a start of a mind control, thought control. So, someone angry about the draft system should be allowed to say, fuck the draft, instead of saying, oh, I don't like the draft, or I hate the draft, right? And that is consistent with UN Human Rights Committee jurisprudence. And yet, there are several countries that still have insult law, including Korea. And anonymous speech is also protected by UN Human Rights Committee. So anonymity is destroyed when the identity of the speaker is revealed against the speaker's will. And UN Human Rights Committee has made recommendations that unmasking the identity of the speaker should be done through a warrant. We lobbied before UN Human Rights Committee October last year, and we received that recommendation on South Korea's law that allow warrantless unmasking of identity of the speakers online. This is about national security law. I'm just gonna skip that. Okay, this critic of insult law, but I'll skip that too. I talked about human rights on free speech, and how does it relate to the internet? Added punishment for online speech, should that be justified? I covered this point in the legal perspective lecture, so I'll skip that. But how about social media, right? Social media is not really content driven. People's communications are not organized by the content of communication, but they are organized by the relationships between people. What you see on your Facebook account depends on not your interest, but your friend's interest, right? And it has a length restriction, and it has much of social media communication is embedded links. Is that and also likes and retweets? These are all forms of communication. Is that reason for reducing liability, or is that reason for enhancing liability? And then there are laws designed to abate the speech. There are laws designed to respond to the nature of the speech enhancing nature of the internet. So, for instance, Korea has this law. Well, okay, I'll talk about Indian law. India used to have law that punishes posting online content that's grossly offensive and menacing. And I mean, it doesn't say unlawful content. It just says grossly offensive and menacing. The idea is that what's lawful offline can be considered unlawful online. Fortunately, this law was struck down as unconstitutional in Sharia single case. Korea has a similar law, like similar law whereby postings can be taken down if it violates sound communication ethics. So things can be taken down not for being unlawful, but for violating communication ethics. That also is an example where what's lawful offline is not freely allowed online. These are all attempts to, these are all outgrowth of a view of the internet as a dangerous space. What should be freely allowed outside the internet should not be allowed freely online. Same thing with the real name, the mandatory identification law. And that also represents, that also is an outgrowth of a view that the internet is a dangerous space. So you can speak as much as you want anonymously offline, but you cannot do that online. Again, this law was struck down as unconstitutional. Okay. All right. Equality, discrimination, and hate speech. Article 20 of ICCPR, I showed you Article 20 already. It prohibits, well, it requires state parties to prohibit hate speech. But what is hate speech? All speech showing hate? No. Only the speech likely to result in hate-led action, for instance, discrimination, is hate speech. And just as the speech can travel farther and faster online, so can hate speech. So that presents a challenge to the governors of the internet. And one question is counter speech also hate speech? Counter speech is a speech designed to respond to, designed to fight, designed to abate the effects of hate speech. For instance, a lot of hate speech against women are countered by feminist websites trying to mirror the insulting nature of the speech thrown against women. Should that counter speech be also restricted online? Another issue when it comes to human rights is whether psychological harm should be a basis for restricting speech. Now, this is different from insult law, because feeling insulted is different from being psychologically harmed, right? So, if speech causes something higher than just insulting a person and causes lasting psychological harm, should that also be a basis for prohibiting speech? Okay, I'm almost out of time, but I'm going to spend 5 more minutes about privacy, and then we're going to question and answers. Now, privacy. Classical privacy infringement takes place when there is an intrusion into privately held area, or when there is a revelation of a privately held information. But privacy has a limit. There is an exception that allows privacy infringement, that is to save life and protect security, etc. When do you need, when do you save life? When do you protect security? Well, one prevailing situation where privacy needs be infringed for public interest, for security purposes, is criminal investigation. And I talked about the Warren Doctrine in my legal perspective lecture, so I'm not going to talk too much about it, but you can just sum it up. You can sum up the international human rights standard on privacy as this. Probable cause only when probable cause is certified in writing by a responsible official independent of prosecutorial interest, meaning judges. Only when that certification comes, the police and the investigating authorities can infringe another person's privacy. And there are like several lower level rules about how the Warren should be applied. I'm going to go into that in when I have free time in question and answer session. Internet and privacy. Now, privacy is meeting a new challenge because the internet creates a lot more room for privacy infringement, and in response, this new law called data protection law came into being, which applies not just to private information, not just privately held information, but also publicly available information. So we should think about whether this data protection law protects human rights, but also has the danger of limiting human rights. I'll go into more detail on this in question and answer session. So I'll stop here for now. Thank you.